owner and managing attorney at Rational Unicorn Legal Services, and I love talking about all kinds of legal concepts because my perspective is as we increase the capacity of our community, we will all be able to do better business together, right? As everyone learns a little bit more about how to do better business, we will collectively do better business together. So today we're going to cover 4 fundamental legal business concepts that at some point in your business life cycle, you are going to have to deal with. Um, Let me figure out how do we advance this. So a little bit about Rational Unicorn. Rational Unicorn Legal Services was founded in Portland. Yay, Portland. Almost 7 years ago. We have expanded now. We serve the whole West Coast. So we have attorneys in Washington, Oregon, and California. And we offer nonprofit and business law to clients in those states, as well as intellectual property law to clients nationwide. And the thing about Rational Unicorn, if you can't tell from our name, is that we practice law a little bit differently than perhaps what you've observed in traditional law firms. You don't often have attorneys naming their firm after magical, mythical creatures, but we hope that it signals to our clients that we're different, that we have that human approach to our business. So when you work with Rational Unicorn, you get attorneys that talk with you, not down to you. We really try to be collaborative in our engagements. We offer free 30-minute consultations for all new projects. We work on a pay-as-you-go flat fee service model, so you never have to worry about runaway legal bills or legal bills that you receive that are way outside your budget. And we're a certified benefit corporation for good. So we follow the triple bottom line of people, planet, and the profit and profits in that order. Just a quick disclaimer, because I am an attorney, we do like to make sure that it's really clear. The information that we're providing and sharing with you today, this is meant to just be public education information. It's not intended to be legal advice. Legal information is very different from legal advice in that we can share principles and business concepts with you, but it's not necessarily applied to your particular facts and circumstances. And so it's not advice aimed at helping you solve a problem or navigate an issue or plan for the future. So feel free to ask questions. I really welcome engagement in these. You are welcome to raise your hand or like come off mute. We will have time at the end to do questions, but I kind of think that as we're going through, it kind of makes sense to have the same context of what we're talking about right now as those questions come up. A little bit about me. I'm a second career attorney. I'm a mom. I'm a proud puppy owner now. My kids are old. I have a senior in high school and one in her second year of college. So it's a little bit strange to have grown kids and then also have a puppy at the same time. It's like we have a toddler again in the house. My background is in industry. I worked at startups and small businesses before I became an attorney. And so I'm one of those kind of unicorn attorneys that not only has business knowledge, but I also have business experience. And I can talk to you from both the perspective of being an attorney and also being a small business owner. I know what it's like. I also have an advanced legal degree in federal taxation. So that kind of makes me a ninja in the sense that we can talk about the business concepts as well as what the tax implications of those are. And I found that's always very helpful when talking with business clients. Okay, our roadmap for today is we're going to talk about business selection and formation. Every business owner hopefully also has a business entity. If you are early in your business journey and functioning as a sole proprietor under maybe an assumed business name, that's great. We can talk to you about like the next steps in your business journey. We're also going to talk about contracts. Contracts are the paper that facilitate all business relationships, and every single one of your relationships ideally is papered up, has a contract around it, so you have clarity and protection in your relationships. We're also going to talk about intellectual property, those things that you conceive in your mind and from your experience with the world, and that you put them into tangible form, whether it's your brand or your curriculum or your guided meditations, whatever it is that you are doing as a business owner, we want to make sure that intellectual property is protected. And we're also going to talk about working with people, whether they are employees or independent contractors, those the workers that you need to help you accelerate and promote your business. So these 4 quadrants, every single business owner will touch upon these at one time or another. That's why we consider them fundamental. So let's get into it. Business formation. Now, the first thing I want to offer here is that there is no one-size-fits-all approach. Businesses are as unique as the owners who run them, right? And so while there may be principles of like, hey, you should form a limited liability company, Or there may be lots of opinions on the internet, like every startup should form as a Delaware C corporation. I want to caution you when you're talking with someone and they're like, well, this is what you need to do. Feel free to press on the edges of that and push back a little bit, because you deserve to have an attorney who's willing to work with you on your particular facts and circumstances and not just sort of push you through into a one size fits all approach. So, when you're thinking about business formation, there's always two layers to consider. The first layer is the state layer. So, if you're in Oregon or you're in Washington, wherever your business is placed, you are going to have probably an Oregon business entity. Now, you may be a sole proprietor and you can run a business as a sole proprietor, but what that means is that you and your business are legally indistinguishable. So, if your business has any liabilities or your business has risk, that risk can reach out and attach to you as a human being. And so, that's one of the reasons that we encourage business owners to form a business entity and to work within the comfort and safety of that business entity. Um, if you're a business entity, well, I guess there's three types here. You could be a limited liability company, a corporation, or a nonprofit. I'm just going to pause. Do we have any nonprofits in the room with us today? Like, if so, maybe could you like put it in the chat? Janine, could you tell me if there's anyone? I can't see the chat because I'm sharing my screen. If you are a nonprofit, we might talk about that at the end. However, all of these are going to apply to you equally. Remember, nonprofits are businesses too. These fundamentals apply to them. So um, here's how I would approach entity selection with any client. I would talk with you about what your goals are, what your business does, what kind of risk you have, and what your growth strategy looks like. If you are a small business owner that provides professional services to folks either locally or through the World Wide Web, basically anywhere, then a limited liability company is probably perfectly fine for you. In fact, you may want to consider special tax treatment to help decrease your self-employment taxes. But a limited liability company is ideal because it's very easy to form and register with the Secretary of State. It's very easy to manage and run from a corporate governance perspective, and it works really well if you are a single business owner. A limited liability company works really well as well if you have multiple business owners, but I do caution you, if you are working with a partner or multiple people in your business, I really encourage you to work with an attorney to ensure that you have the appropriate business documents in place. Here's a secret. You do not need to be an attorney to form an LLC or a corporation. Anyone in the world can go online to the Oregon Secretary of State website, can fill out the paperwork, and file and register their business entity. There's no secret sauce there. You don't need a law degree. You don't need any experience. The website has lots of information. You are empowered to go and do the things that move your business forward. If costs are a barrier for you, I recommend working with an attorney on the things that you will get the most bang from your buck from, right? If you are working with a business partner, I don't recommend, for example, drafting your own operating agreement. You should work with an attorney to make sure that your interests are protected, that your deal is properly articulated, that you have a clear understanding of all the different protections and different legal things that should be included in that. But again, if it's just you and you're running your own business, you don't need an attorney to do this work for you. You save your money, spend it on other areas where their expertise is going to be more useful. After you figure out what type of entity you want to be, whether you want to stay as a sole proprietor, you want to be an LLC or a corporation, then you need to think about what tax treatment, what tax layer you want to put on that. Tax is the second layer that we think about when it comes to businesses. Now, a sole proprietor can only be taxed as a human, right? That's going to be a disregarded entity. All of the business deductions, expenses, revenues, et cetera, will be reported on Schedule C and filed with your regular tax return. If you have multiple people in an LLC, that will be default treated as a partnership. So there's sort of, the IRS has a couple of different sort of default paths that they send entities through. LLCs are a little bit magical in the sense that they are the only entity that can choose how it wants to be taxed. So an LLC can be treated as a disregarded entity if it's just you. If you have business partners, it will be default treated as a partnership. If it's just you or business owners, you may also opt in to being taxed as an S corporation or as a C corporation. So you see, like LLCs, they have the whole world available to them when it comes to tax treatment. And so you can see that the choice is a little bit nuanced. And like I said before, since there's no one size fits all approach, sometimes it's really helpful to sit down with an attorney and talk about, here's my goals, what is the right vehicle, the right entity to get me there, and am I working in the most tax advantaged environment for me? Have I selected the most advantageous tax treatment? So those are questions that a business attorney can help you resolve. So that's your entity. Does anyone have any questions about that, or should we keep going? Okay, we're going to keep going. Now, I love contracts. I'm a business attorney. Contracts are, pretty much what we do. I was explaining to my son, my senior son, he says to me, Mom, what do you do? Do you go to court every day? It's so funny. Like teenage boys, they never listen, right? They're just absorbed in their phone and their Xbox with their friends. And I'm like, no, babe, I'm a transactional lawyer. That means that I'm forward looking. I'm helping clients with like contracts and transactional documents, like agreements and things that help promote their business and help facilitate their business and help protect them. Like that sort of forward looking work is what we love. We try to prevent and avoid disagreements or issues by drafting strong contracts up front. And so I get very passionate when we talk about contracts because here is what makes them so magical. We're all familiar with like our statutory laws, right? Speeding laws, criminal laws, civil laws that say your house can only be this big on this lot, or you can only go XYZ fast on these streets, or school zones have a, right? We're very familiar with those statutory laws written by our legislature. Contracts are what we call private law. When you and the other person sign that document, it becomes every bit as enforceable as statutory law that is voted on by our legislatures and put into practice. So contracts, you and your business partners, or you and your clients, you and your vendors, have the ability to sort of create this document that privately between you, you can agree on the terms. And if you agree to those terms, the court will enforce them every bit as much as they will enforce our statutory provisions. And so contracts can be a very, very powerful thing, both for good and for evil. I tell my clients a lot, like, please read the contract before you sign it. If you don't sign it, we can negotiate things on it. If you do sign it, then we're stuck with whatever you've agreed to. Um, we can work magic, but we cannot work miracles. Like I still haven't figured out the ability to do that. So um, I love contracts. I love to use them with my clients. I find them to be very empowering for my clients because they feel protected. They feel like their business is facilitated. They know they have a professional document that they can share with their clients and the people that they work with that will help promote and enhance their business. And really what it does is it portrays you as a true professional who takes your business seriously and who has gone to the lengths of putting appropriate contracts in place to help facilitate your business. I am not a person that loves long contracts. I don't like a lot of legalese. I think contracts should be written in plain language where people can understand it. I don't want my clients to come to me and say, I don't understand this provision the way you've written it. If you don't understand your contract and it's scary to you, then it's probably going to be scary to your clients as well. So my goal when working with clients is to draft you a contract that is short. It appropriately protects the risk in the relationship or the engagement. It facilitates your business and it enhances your relationship with your clients. And if your clients see a poorly written contract that is not formatted well, has duplicate clauses in it, is messy or just not overly long or overly verbose, it's going to scare them away. And we don't want that. I don't want to scare any of your clients away. I've failed at serving you if I'm chasing your clients away. So we really work to make sure that there are contracts that are acceptable and that really promote the business. So contracts, as you can see on the slide, they're super essential. They're going to protect you from misunderstandings. They're going to prevent disputes about who said what or who was supposed to do what. Contracts If it's not written down on the four corners of the page, it doesn't exist. Once you've signed a contract, almost all of them have a clause that says this is the entire agreement. Nothing else is going to be used to interpret this agreement or to lend additional weight to this agreement. That means that anything on the four corners of the page is enforceable. But if it's not in that contract, if it was left in an email or a text message, or you just had a casual conversation about it, if it's not written down, it is not legally enforceable and it kind of doesn't legally exist. And it cannot be used to then come in and interpret the contract because the contract does have that provision of like, this is the entire agreement. So contracts are a double-edged sword. They can be great, or they can be, we're all adults here, they can be kind of shitty, right? If they're not well written or if they don't appropriately just protect you from the risk in that relationship. They're a legal safeguard, right? We talked about that, the idea of they're enforceable by a court. A court will look at this document and enforce it for you. So if someone doesn't follow through or if they break the contract, then we've got a legal document where everyone agreed to it, where it can be enforced. And like I also said, it gives you that professional image, right? It builds trust. So bottom line here is use contracts. Don't be afraid of them. Do not be naive and too trusting. Make sure that your business agreements, your business relationships are protected with contracts. Okay. Any questions about contracts? Okay. We will keep moving. One of the types of contracts that we use the most and that we advocate that any client has is some version of a client services agreement. This could be as simple as like terms of use on your website. It could be as simple as like a 3-page document that you send electronically to your clients to sign before they schedule services with you or before you plan an event. It could be, several pages depending on the complexity of the relationship or the length of the relationship. It could be several pages that outline maybe the website you're developing for them or the review process for that. So whenever, if you have a client services agreement now or terms now, I encourage you to go back and review them with these things in mind. And if you don't have one, I encourage you to reach out and chat with us, schedule a consultation. We will help you get a client services agreement or some sort of terms in place. Just like any good contract, your client service agreement is going to outline the expectations. What are the services or the goods being provided? What are the timelines and the cost? Making sure that from the very beginning, you and your client are avoiding any confusion and ensuring that you are fully aligned on what you're trying to do. It's legally binding. It can be used to protect your rights and your interest. For example, if your client has an event and they cancel like the day before, your contract would say, sorry, you still owe me everything because we have done almost everything for this event and now you cancel the day before. So it will protect your rights and interests. It's that professionalism thing. It really demonstrates to your clients that you're serious about delivering great services and building a good reputation. Make sure that they're detailed and specific. The things that folks are going to argue about are, did you give me the right thing at the right time for the right price, right? Think about where are folks likely to be dissatisfied? And it's one of those things. Either the thing that you delivered for me, the service or the good, wasn't what I expected, or it was on a timeline that we didn't agree to, or like pricing terms that we need to fully be aligned on. So please be really specific. Janine, I saw you come off mute. Do you have a question?
I'm reading a question in the chat
Oh,
about
great.
MSAs and SOWs and their relationships. So I'm just going to read it. Brandon
Okay.
asks, I don't want to get in front of you, but is this the same as an MSA? What's the difference with an SOW? I usually have both MSA for the overall and SOWs for each batch of deliverables.
Brandon, that is a great question. Thank you, Janine, for alerting me to it. So an MSA is it stands for Master Services Agreement generally, right? And that's generally like, yes, like we're saying, that's sort of your client services agreement or the thing that you use to set the terms of your relationship. Now, an SOW is a statement of work or a scope of work or like a scope of services that is attached to that MSA or client services agreement so that you can continue to do multiple projects right, for that client under the same terms. So you may have a client service agreement and you're like, okay, today we're doing this thing for you, right? We're revising your website. Maybe you come back and you say, you did such a great job on my website. Now I want you to build me a forum where we can go and all the people who have, I don't know, bunny pet bunnies can come and chat about like their bunny hutches, right? And okay, so now we have a forum. That would be a different statement of work or scope of work. And that's an excellent way to facilitate your business because the terms of the overall agreement will control the entire relationship, but the scope of the services will be bound by whatever is in that specific statement of work. And so I encourage you, if you use that approach, make sure those statements of work or scopes of work are very clear, right? Think about the way that we write SMART goals, right? Specific, measurable, time bound, whatever all those things stand for, right? So write your scope of work in the same way with the same level of precision. And then if you get some really good, like you're like, oh, I really like the way I worded that. I should use that with my next client. Write some templates for yourself so that you can like not recreate the wheel every time. I want you guys using contracts to facilitate your business. I don't want your contracts becoming your business. I don't want you spending lots of time on things trying to just write contracts so you can go out and protect your business. Okay. Yes, Brandon, templates, baby. I love it. I love templates. Okay. Include dispute resolution terms. Always, always, always include dispute resolution terms because we don't want to send people to court. Court is a messy, expensive, uncertain place to be. I know that sounds like a weird thing for an attorney to say, but I am a big fan of alternative dispute resolution, mediation, good faith negotiation, if you have to, maybe arbitration. But really, when you think about how expensive it is to solve disputes versus just resolve them, right? Like, let's just peacefully come to an agreement so we can undramatically uncouple, right? You don't want to work with a client who doesn't want to work with you anymore. That's like the worst case scenario, right? And if you don't want to work with the client anymore, there we need to find a way to resolve whatever it is that is causing an issue. And then if you need to, let's terminate the contract or peacefully uncouple and walk away because um, again, we're just trying to promote business, not promote controversy or adversarial things. So I encourage you also to tailor your statements of work or your client services agreement to each client, right? Especially in that statement of work where you're like, okay, this client needs 4 hours a week of support, but this one needed something different, right? So tailor it, make sure that it fits well. If there's things that don't apply, make sure that you note that so that the client isn't like, well, there's this thing over there that you told me about. And you're like, no, that's not relevant to this engagement. Make sure that's noted. And then review and update them regularly. Laws in the business world change fairly rapidly, and we, as business owners, have two bodies of law to look at, both our local state law and federal law, right? And so sometimes there are federal agencies like the FTC. They're putting laws into place that are going to prevent things like non-competition agreements. And so we need to be aware of those as business owners, both at the state and the federal level. So update and review your contracts regularly just to make sure that they work. In fact, I would just put it on your calendar to do an annual review. Like, all right, I'm going to sit down. It's like a little legal checkup for my business. Sit down, review your contract, identify, are there things that I always have to answer questions about in there? Change that, right? So that you like anticipate the question and answer it. Are there things where you're like, man, my clients keep showing up late to meetings. I need some sort of cancellation policy or like late policy. Let's add that in there. Let's make sure again that your contracts protect and promote your business. Let's see. Confidentiality agreements are another form of client of a contract that you will use in your business. I'm sure folks are very familiar with these, so I will cover this briefly. Confidentiality agreements protect your secrecy of whether it's your business, your intellectual property, your proprietary process, whatever it is, they will cover almost any type of information. You can make them durable for like a year because in a year this concept will be there gone, or for a lifetime because maybe forever your proprietary process or your like process of, I don't know, blending your tea or putting together your candle scents, right? Those things may be proprietary forever and you never want them to be disclosed. It gives you the ability to, if somebody starts opening their mouth and blabbing about these things, it gives you some ability to enforce that. So if there's a breach, you actually have a remedy for that. And they can be mutual or unilateral, right? If you are the only one disclosing things, you don't need to be bound. You know your secrets. You know you're going to keep those things locked up. So if you are only disclosing them, to your vendor or something so that they can make this blend for you, or your co-packer so they can make your recipe for you, then maybe you need unilateral. But if it's like a business engagement where they're sharing information, you're sharing information, it's kind of free flowing back and forth. I really recommend a mutual NDA. Now, there are other protective covenants that you can put into agreements in addition to the obligation of confidentiality. One of those that we always recommend is a non-solicitation clause. And this is great for protecting your clients or your employees. If they leave the business, that person can't take your clients and they can't try to recruit your staff, right? It really protects the business's interests and all the work you've done to develop those relationships and train your workforce. A non-compete clause is another thing that you can use. It stops a party, usually an employee, from working with direct competitors or starting a business within certain geographic areas or in certain time frames after leaving the company. This is a rapidly changing area of law. It is changing on the state and the federal level, and it's like different every single week. There's always something new about, like, some federal judge in Texas stopped the non-compete law, or Washington passed their new non-compete law, or Oregon. So there's always something. And I'm just going to say, there are ways for you to protect your business without using non-compete clauses. The FT, we are going to have a seminar on this. Rational Unicorn will, in October, and I encourage you to attend because we will talk deeply about these things. But here's what I would tell you right now. Because non-compete agreements are so uncertain, like, seriously, they're so uncertain. We just don't know what's happening with them. I recommend that we think about protecting your business in other ways by using these other protective covenants: confidentiality, non-solicitation, and non-circumvention. And I mean, you can tell people, like, yeah, I don't want you to compete, but they're only enforceable in certain situations. And this is interesting. If you have, for example, an independent contractor who's located in Washington, Washington's non-compete law is going to cover them. And Washington says you cannot have an employee with a non-compete law unless you pay them more than 120,000, and you cannot put an enforceable non-compete provision in with a contractor unless you pay them more than $300,000 a year. So you can see, like, there's some very strong financial thresholds that you have to meet in certain states in order to know whether or not your non-compete clause will be enforceable. Thank you, Janine. I appreciate you dropping that in the chat. So, rapidly evolving area of law. If you have non-compete clauses in your documents, I strongly consider you having those reviewed by an attorney just to ensure that they are enforceable. And especially if you work with contractors from other states, be aware the state where that contractor has boots on the ground, that's the law that will apply to them for non-competition agreements. So if you have a contractor in Ohio or a contractor in Arizona or somebody really fabulous in Maine, beware. You will have to research and understand what the limits of their non-compete laws are, if any, to know whether it's enforceable. And so that's why I just advise, let's make sure you have enforceable protective covenants in other areas, and let's not focus so much on the non-compete, because it's just so uncertain to know how those will be treated and enforced in the future. My most favorite protective covenant is probably the one that folks know the least about, and that is a non-circumvention clause. What does that mean? That's a big word. This prevents anyone. Okay, let's just say it's like you and a business partner, and you're like, hey, I have this really great idea. And look, here's other people who will help me do it. And I've identified this supplier and I've identified this, space that we can rent, and I've identified these people who can do all the other stuff. Isn't this great? A non-circumvention clause prevents them from going to all those people that you've introduced them to, or those resources, or taking a hold of your idea, circumventing you, and pursuing those things on their own. And so it permanently ties you and that person together in any of those proposed business ventures or ideas or strategies. And it says, you cannot move forward unless I'm a part of these things. And so it locks you into the deal and ensures that you receive those exclusive rights and the benefit of the bargain that you intended when you're introducing those posts. So a non-circumvention is one of my favorite things. I will try not to be, I'm going to stop. Nobody loves a long-winded lawyer, and I'm not going to nerd out over this. Okay, let's keep going. Any questions about protective covenants? Okay, we're going to keep going. Intellectual property. I apologize for the wall of words here, but let's just talk through it together. Intellectual property are those creations born of your mind, your experience, your relationship with the world and your surroundings. They are the things that are like our intellectual capital, the thing that we bring into our business and we create in tangible forms. They can be anything from inventions, literary and artistic works, designs, symbols, names, images. You as a business will likely have multiple forms of intellectual property that will need different types of intellectual property protections. So, for example, if you have curriculum that you use, if you have, if you do like group work or you have a workbook, things like that, you should copyright it. If you post blogs online or information on social media or like brief videos on TikTok or Instagram, you should copyright those things, right? Um, let's talk a little bit about the different types of intellectual property and the different types of protection that you as a business owner might want. Copyright, the right to that item. It protects creative works, right? Like photographs, jewelry designs, architectural drawings, schematics, paintings, photographs, blog posts, social media posts. The Copyright Office is actually pretty hip. And as it sounds weird to say about a government agency, but as new things come up and they're like, oh, we need to be able to protect blog posts, for example, or social media posts. And so they've developed new applications for that. You have the copyright as soon as you put that idea into tangible form, as soon as you write that curriculum down in a Google Doc, as soon as you snap that picture on your phone, as soon as you sketch it out, that design on your tablet, that is, you have that, you own it, that you are the author of that. But in order to protect and defend it and protect anyone from infringing against it, infringing just means steals your idea, you must register your copyright. I've had so many creative clients recently come to me after somebody has stolen their work. Like, how do I fix this? Somebody stole my jewelry or somebody stole my design. It's really hard to defend a copyright that hasn't been registered. And so I want you to think about your most valuable assets and the ones that are like the most popular on Instagram, or the designs that always get shared, or the things that people are always asking for the link for, or um, like that high demand thing that you have, or that really special thing where you're like, nobody else is doing this. This is so cool. Please consider registering that copyright. Think of it like a very low cost insurance policy. You, as the author, can copyright your original work for $45. That's it. You can do a group of up to 10 for 85. You can do 750 photographs for 85 bucks. Like, there's all of these different ways that you can shove a lot of content onto a copyright application to decrease the cost. But the important thing to keep in mind is this: if somebody infringes or steals your copyrighted material in a way that is not authorized, then you can send them a cease and desist letter letting them know that your copyright has been properly registered. You are the author and they are unlawfully infringing on it. And those three elements will get you into any federal courthouse in the country on a copyright infringement claim. And if you are able to establish those three things at trial, I'm the owner, my work was properly registered and they infringed on it, you're eligible for $30,000 in statutory damages. We call them statutory damages because the statute is the one that sets the amount of damages. You don't have to prove that you lost 30,000 in sales or suffered $30,000 worth of harm. You just have to prove I'm the owner, it was properly registered, and they infringed it. If you can show a fourth element that the infringement was intentional, those statutory damages go up 5 times to $150,000 per copyright infringement. And so you can see how that either one very quickly acts as an effective way to dissuade people from stealing your copyrighted content, but also acts as a really strong insurance policy if it's ever infringed upon. You can just go back and say, I'm the author, it's properly registered, they infringed, and that infringement was intentional, whether it was or not, right? We'd have to establish that. And then you're eligible for $150,000 of statutory damages per infringement. So copyright is really important. Registering your copyright, especially for your high value assets, the ones that you may want to commercialize and promote and ensure that they stay protected, it's even more important. So that's a little bit about copyright. A patent protects inventions, and patents are a lot harder to get. They also require that you fully disclose your entire invention, and then you will get 20 years of protection where you have the exclusive right to use that invention and to promote it and to commercialize it. That's the benefit of a patent. But it has to be something that is, what is the phrase? Something like not immediately apparent to those with ordinary skill in the art. So, for example, like a laser pointer. Everyone has seen a pen and everyone has seen a laser, but putting them together into a laser pointer was revolutionary and it was not immediately apparent to those with ordinary skill in the art. But if you were to be like, oh, a bicycle, I know, let's put a third wheel on it. That's new. People would be like, no, that is not a new invention. Folks have done that before, not eligible. So patents are hard. Patents are also really expensive. Like you should plan on $15,000 to $30,000 per invention. And that's because you have to get drawings, you have to submit it to the patent office, you have to have a special patent attorney or patent agent help you with it. I'm not a patent attorney. You have to have a technical degree to be a patent attorney. I have a law degree. We do have a patent agent though with Rational Unicorn. So if you have ideas that you'd like to discuss that you think may be eligible for patent, the number one piece of advice I can give you is don't tell anyone about it. Because as soon as you share your idea or your proposed invention with somebody and it's not under a confidentiality agreement, it's considered a public disclosure. And then you only have 1 year from the date of that public disclosure to get your patent filed, or else you have lost out on it forever. So it's really important. Like Brandon says, the first rule of patent law is zip your lip. Don't tell anyone. Protect it first. And then through that act of protection, you're going to have to fully disclose everything. So they're going to know sooner or later. And if you are talking with folks about your secret inventions, please use a non-disclosure agreement. Okay. Okay, trademarks are very different from copyrights and from patents. Trademarks protect your brand or like your company persona in the marketplace. Um, Trademarks are for things like logos or slogans or perfectly like selected, curated set of trade dress. Like these are our colors and our design, right? Like Rainforest Cafe, if anyone remembers that restaurant, their interior design with all of those rainforest themed decorations, that was trademarked. They trademarked their trade dress of the restaurant so that there was nobody else that could come and do a rainforest cafe themed restaurant. So there's a lot of things that you can trademark. The process is lengthy. It takes anywhere from a year to 2 years. And the nice thing about the trademark process for business owners is that the way that it's very affordable to do because it's like first we do this part, okay, then we wait, then we do the application, okay, then we wait, then we see if they have any objections to our registration and we respond to them and then we register it. So it's like a long process, but everything is neatly sort of spaced out so that it makes it easy to pay for it and like go through the process. You don't have to spend all of your time thinking about trademark or all of your money thinking about trademark. Only a little time and a little money every 3 to 6 months. Trade secrets, whoops, we're not going to go there yet. Trade secrets are anything that is confidential that you do not have protected under one of these things. So, for example, You cannot copyright a recipe, right? Because it's just like a list of ingredients. So if you had a recipe for your hot sauce or your sugar cookies or your mango chutney, you would want to protect that as a trade secret. You don't want to patent it. We can't patent that. Plus, you'd have to fully disclose that. It's not eligible for trademark. Trademark is about your branding and your identity. Copyright won't let you copyright just a list of things, so we have to protect it under trade secret. So there's a lot of things that are going to fall under that trade secret bucket, and that's another good reason when you're working with anyone, even folks that you're in business with, having that confidentiality agreement or including that confidentiality clause in your client agreement will protect your information. Okay. Any questions about IP? Okay, we're going to move. We're almost done, and that's good because I'm coming to the end of my time. We're going to talk about working with people, employment. So the number one question that business owners have is, how do I know if they're an employee versus an independent contractor? You're going to work with both. Very likely you will work with both at some point in your business career. Either you will hire a part-time employee or a full-time employee to help you manage your work. You're going to hire independent contractors, maybe to take on aspects of a project where you don't have expertise or to help lighten your load. There's going to be I know almost no business owner who can do it all on their own. Like, share the load. There's lots of qualified folks who can help you. The, the big consideration is, are they an employee or are they an independent contractor? I understand how daunting it can be to have an employee, right? It's like I have to register with all those state agencies. I have to figure out how to do payroll. I have to like think about withholding taxes and, like tax forms and all that stuff. And it is daunting. But even worse than going through all of those things once to set up your employee, right? It's like, okay, those things are all daunting and you will do it once and then it will be done. Worse than that is getting a call from the Department of Labor or Bali saying, hey, we think you misclassified your employees, and here is $70,000 of back taxes and fees and fines that you have to pay for this. Like, that is just a terrible place to be. And I don't want any of you to be put in that situation where you are receiving a call or a letter from Bali about your employment practices. So I encourage you, do not be daunted about hiring an employee. If your analysis says this person should probably be treated as an employee, reach out to us. We will help you figure out how to navigate that process. Hiring a person right is so much better than having to go through like an employment audit or a Bali audit, right? Like, it's so much better. There are times when folks will be legit independent contractors, but the state public policy is to classify folks as employees because employees get access to benefits that we want them to, like from a policy level, we want them to have. An employee will be eligible for things like paid family leave or maybe paid sick time or at least unpaid sick time, right? Those are things that the law guarantees to all employees if their employers or reach a certain threshold, right? So it's it's better to do those things right, than to be audited. And public policy, the pressure is very strong to categorize people as employees versus independent contractors. The main question is whether they have control over the work, sort of the means and the manner of controlling their work. And do they have the ability to hold themselves out to other people for similar kind of work? Like, for example, an attorney, for sure, an independent contractor to you, right? Like, you're not telling me how to do my work. You're telling me the guidelines. Like, these are the people, these are the terms that we agreed to. This is what the agreement's about. But I manage my work. I use my independent judgment. I hold myself out to other people to be employable in this way, right? Like, I'm clearly an independent contractor. But if I was working for you and you're like, okay, Lindy, I need you there between, at least 3 hours a day, and these are the things that have to get done, and here's a computer to do it on, and here's an email address to use, and please use my systems, and this is how I want you to respond, and here's the templates to use. If it looks like a duck, it acts like a duck, it's probably going to be a duck and not an independent contractor. And we want to make sure to have our ducks in a row, nice and neat, so that when Bali looks in, they don't have anything, there's like nothing to notice here. I will also say The number one way that Bali knows that you are maybe characterizing folks as employees instead of independent contractors is because you will have a disgruntled contractor go to Bali and complain, right? You will maybe say, hey, I don't need your services anymore. Thanks so much. Or maybe this didn't work out. We're going in a different direction. All it takes is for them to go to Bali, file for unemployment, and then protest like, well, I should have been treated like an employee because I did all of these things and I was misclassified. That's the number one way that Bali knows you're not treating your employees the right way, or that any flags get raised for them. It's not like they're just knocking on your door and being like, tell me, do you have employees or independent contractors? And let's go through this checklist. There is a federal test that the IRS uses for determining whether or not folks are employees versus independent contractors. There's like 11 or maybe 17 different criteria. Every single state has a way to determine whether they're an employee versus an independent contractor. It's like a complex analysis. I don't want to go into those details, but overall, you need to be aware of these differences. And also, you have to be aware of where your people are located. Because again, if I have my boots on the ground here in Washington and I'm working with somebody in Oregon, it's like if I'm hiring an employee from Oregon or an independent contractor, it's Oregon law that will apply to them. Or if I'm hiring somebody in Washington, it's Washington law. It is the law of the state where that human's boots are on the ground that apply to them. So even if you're in Oregon and you're like, hey, it looks good, Washington's going to have a say about it, right? And we don't want the states being involved. We just want to do good business and keep that privacy around us, treat people really well, and take good care of them. I'm going to pause here because I want to make sure we have plenty of time for questions. So does anyone have any questions or things they'd like to bring up about any of the material we've covered today, or things maybe we didn't cover?
I have a question, Lindy, about an acronym you used.
Yes.
You said Bali. Who?
Oh, so that's the Bureau of Labor and Industries in Oregon. That's
Mm,
the Oregon like employment security. So if you have employees, Bali, the Bureau of Labor and Industries in Oregon, is going to be the one that tells you whether you're doing it right or wrong.
okay, thank you.
You're welcome.
Hi,
Okay.
this is Brandon. I have a question, and it feels like I'm a high schooler trying to get away with plagiarism. But when we're talking about intellectual property,
Mhm.
exactly to what degree are we discussing? Like copying words, copying photographs are easy. But if a course is something that's copyrighted, is any of the phrasing in there copyrighted, or are they the concepts that you need to make sure you're not infringing upon? How deep does that go in something like that?
Uh, oh, here's my
How
dog.
deep might that go? Hello. Hi.
This is Atlas.
A
He is
special
joining in.
expert.
Yes, yes, special expert. He knows a lot about this topic, so I'm glad you asked. Okay, there is this thing, a concept known as fair use under copyright. And fair use allows you to use some portion of the copyrighted work for public comment, educational, political analysis. There's four factors of fair use that you have to weigh. Now, fair use analysis is a really complex analysis because you have to think about how much of the work they are using, if they're using the core of the work, or only like a little bit of it, if their use of that portion of the work basically eliminates the market for the original work. So, for example, if we had an encyclopedia with 1,000 pages and you quoted one paragraph about, I don't know, the red-tipped robin, and you're like, this is what the encyclopedia says about the robin. Now you're not copying 1,000 pages. You're only doing one thing. I don't think anyone would say the robin is the center of the encyclopedia, right? But if you have like a curriculum where you're like, okay, here is the quiz to know whether or not um, you have childhood trauma, right? Or whatever the thing is. If they basically take the whole quiz from you and you're like, well, I mean, all that was left was like an intro and a like closing paragraph. They took essentially like the heart of my work. That's like a pretty clear indication that that is not fair use. That is infringing. And so if you have if you know of folks who are infringing your stuff, let's talk about it. Or if there is work that you want to use and you are uncertain whether or not it falls under fair use, let's talk about that too. Like we recently helped a group of folks with a documentary where they were using like 20-second clips from all of these old movies about like the role of LGBTQ in Hollywood way back in like the 20s and 30s and how it influenced the media now. And it was fascinating because they had all these like clips and all of these things. And we didn't have to get clearance on those because a 20-second clip out of a movie, especially if it's not like the spoiler of the movie, right? Like that is fair use because we were using this as an example to talk about this premise. But I suppose if we were like recreating all of Godfather, that would definitely be not a fair use. Does that answer your question, Brandon? This is one of those dissatisfying things where you're like, it depends.
Oh, I completely understand both the it depends and your answer.
Okay, perfect. Any other questions?
So just well, oh, sorry. I was just
Go
going to
ahead.
follow up on Brandon's question. So I'm hearing that like we should consult an attorney if we're not sure if there is an infringement, but I'm wondering then, does that mean that we need to consult an attorney if we want to send a cease and desist? Like, is there a template online you could just use and send it, or is that always something you want to have an attorney do with you?
Um, if your item is not registered, I do recommend that you send a cease and desist. Like, don't get an attorney involved yet. I mean, do what you can, Elizabeth, to protect your intellectual property. Don't wait. Don't wait to go hire legal counsel, right? Like, send out that cease and desist. You're not allowed to do that. If your item is already registered and protected, though, I do recommend using an attorney because then that could be considered pre-litigation. And we really want to make sure that we're saying all of the right things to scare them appropriately. And if you are a person that often has your work infringed upon, we can work together to get you a cease and desist template that you can just have on hand so that you can just sort of fill in like, this is the thing that you infringed upon. Here's the copyright registration. Here's what you did. And you can use that so that you're not tied to an attorney every time you need to facilitate your business. I don't want to do that to you. I want to give you the tools you need to do your business.
Thank you. That's really helpful. I appreciate that.
Yeah, you're welcome. Any other questions?
Yes, I was just
Okay,
curious if you could go back way, way back.
way back.
You talked about LLCs and, they're magical because you can really be taxed in multiple ways. I have an existing LLC. It's just me, so it's very straightforward. But now my partner and I are talking about having an LLC. And so with two people involved, like, how does that shift your process of deciding the tax treatment?
So with two people involved, you're going to be default taxed as a partnership, which means you'll file an 1065. And it doesn't mean you're going to be taxed at the entity level. You will just do a information filing. You will send out K1s to each member, and those K1s will tell you what you put on Schedule C and your tax return. So like partnership tax is pretty straightforward. It can be highly complicated. It's the most complicated like section of the tax code because business owners are very smart and very creative with their taxes. And so the tax code has expanded to accommodate all that, let's call it creativity. Um, if you and your partner want to be taxed as something other than a partnership, like maybe you want to be taxed as an S corp, reach out to me and I would be happy to have a consultation with you and talk about it. You're still going to have to do similar filings. Like either way, you're going to have some sort of tax preparation for your business, whether you do it yourself or you hire someone. But adding a person into it is going to increase the complexity. This is why we say married partners should not be on their LLCs together. Like one of you or the other, but by putting both of you on it, even though like, oh yeah, everything's equal, we share everything. No, you're just putting yourself into like a tax situation that you don't need, right? So, yeah, please reach out to me. I would love to. In fact, let me go back so that you guys can see my contact information, and you guys can always go to rationalunicorn.com and fill out the contact form there. But I would love to chat with you. I love to talk about taxes. I will try not to nerd out, but no promises. Any other questions? Okay, I just want to say thank you. Thank you so much for your attention. Thank you for attending. Janine will follow up with all of the attendees to make sure you have a copy of the recording, as well as information about how to join ORPIB if you are not already a member. Thank you for being here today. It's always a pleasure to chat with you. I hope I hope this was a good use of your lunch hour.
Indeed. Thank you so much, Lindy. I dropped the links to the next 2 sessions that you're presenting with ORPID,
Thanks.
the next 2 Tuesdays. Man, we'd love to see you all back here doing deeper dives into contracts and employment stuff.
Awesome.
Yeah, really appreciate you all being here. Thanks so much.
Thanks, everyone. Have a great rest of the day.
Bye-bye.
Bye.